Okay, so our next talk, you're going to get a twofer. We actually we have an additional speaker that we're adding in, same amount of time. So our first speaker is Steve Pachman. He's a partner at Montgomery McCracken's litigation department in Philadelphia. His practice concentrates on defense of traumatic brain injury cases, representing individuals and school systems in catastrophic sports injury matters. The second speaker is Dylan Henry. He's an associate at Montgomery McCracken's litigation department, focusing his practice on commercial litigation. Please join me in welcoming both of our speakers.
Thank you, Steve, for that lovely introduction. It's an honor to be here. So for the past 14 years or so ago, I have been advising athletic trainers and team physicians in schools and sports organizations on how to stay out of legal trouble. And over that same period, I have defended a number of athletic trainers, team doctors, sports organizations, and schools who have been sued, and sued specifically for breaching the standard of care with respect to the management of sport-related concussions. And on the screen, I have identified some of the schools and sports organizations that we have represented and worked with over the past several years. So when I was at this podium, I guess around four or so years ago, I spent a fair amount of time talking about the standard of care and how, because the standard of care continues to evolve, it makes it harder for defendants and potential defendants to make sure they're meeting the standard of care. And today I'm going to follow up on that discussion a little bit through some recent cases that we've handled involving standard of care related issues. I'm then going to shift, and Dylan's going to take the lead on this, going to shift to the unresolved science and the role that it plays in making it easier for plaintiffs and plaintiffs' lawyers to file these premature return to play cases and other litigation matters. And we're going to do that, Dylan's going to do that through some recent CTE cases that we've handled, that my firm's handled, and some other CTE cases that have been filed over the past year or so ago. So one of the questions that I'm often asked is, who are the potential defendants? Am I a potential defendant? Is he a potential defendant? Is she a potential defendant? And the short answer, unfortunately, is everybody is a potential defendant. Everybody gets sued in these cases, from the coaches down to the athletic trainers who are primary targets in these cases. We've represented team doctors, as I mentioned a moment ago. Athletic directors get sued in these cases. And of course, the colleges, high schools get sued as well. So I believe the last time I was here, I touched on the Sheely case. That was a high-profile case in which we represented individuals at Frostburg State University. So I'm not going to spend much time on that today. In the middle is a relatively new case that we handled. That's Casey Conine. I'm going to talk about that case in a little bit. That's a case involving an alleged premature return to play of Casey Conine, and that was a case in which we represented the head athletic trainer at the University of Illinois. And on the right is Patrick Risha, who tragically committed suicide, and that led to a lawsuit, a CTE lawsuit, filed by Patrick Risha's mother. I'm going to come back to that case in a couple minutes. So what's the theory of liability, of legal liability in these cases? And there are a number of potential theories, including product defects in the helmet cases and the football cases, but I'm going to talk more about negligence today, because in almost every one of these cases, there's a negligence cause of action. And negligence is a term that you're all familiar with, but legally, it's the failure to conform to the required standard of conduct, which means the departure from conduct expected of a reasonably prudent person under the circumstances. So if you are a defendant in a case and your case goes to a jury, the jury will ultimately have to ask and answer the question of what would a reasonably prudent athletic trainer or physician or school have done under the circumstances. And negligence is a four-element claim: duty, breach, causation, and damages. The first element, the duty element, is generally pretty easy to make out for the plaintiff, because there's generally a duty between the healthcare provider, the clinician, and the player who becomes the plaintiff. The damages, the fourth element in a negligence claim, is also easy to make out. In many cases, the players have either died or suffered clear catastrophic injuries. It's the second and third elements breach and causation, which are a little bit trickier for the plaintiffs to make out. And I'm going to come back to those two elements in a couple minutes. So another question that I'm often asked is, well, why are these concussion cases, and you'd have to be living under a rock to not know that these concussion cases continue to get filed by these plaintiffs' lawyers. Why are these cases more popular today than ever? And I've identified a couple of reasons. The first, and we don't have to, this has been touched upon before, the Amalu report. It seems like literally every day we're learning more and more about concussions. And that's really what got things started, as well as some articles by the New York Times. Just the other day in my hometown paper, the Philadelphia Inquirer, there was a real good article done on the recent CHOP study, Children's Hospital Philadelphia study that was done. Tina Master, who I'm working with on another project right now, was one of the authors of that document. And that study found that 1 in 6 children who get a concussion will have another one within 2 years. So it's literally every day, it seems, that we're learning more and more about concussions. The second reason for the increase, and in litigation, and we've beat this one up pretty good today, is the media. The media is all over this topic. There's the front page of the New York Times, the 110 out of 111 study that Ann McKee did. And I found that statistic, bottom left, interesting. That was courtesy of a talk that Kevin Guskowitz gave a couple weeks ago that I attended. I thought that was a really interesting statistic that from 2003 to 2017, the New York Times has run 333 articles on CTE, which boils down to about 25 a year. So do the math. It's really unbelievable. And again, the media is all over this topic, and that leads to more and more litigation from my perspective. The third reason, and I touched on this a little bit earlier, is because the standard of care continues to evolve. And I recently wrote an article entitled "The Legal Aspects of Concussion, the Ever-Evolving Standard of Care," in which I take the reader through some of the recent cases that I've handled. And that's, again, a reason for why these cases continue to be filed, because no one's really sure what the standard of care is, since the standard of care continues to evolve. Just over the past couple years, before audiences like this, I've received a whole host of questions on the standard of care, such as neuropsych testing. Is impact testing required to meet the standard of care? What about with respect to documentation? If I'm a clinician, do I need to be documenting positives, negatives? Do I need to be documenting both? Do I have a duty to preserve my documentation, which you do, but the question becomes, how long does that duty last? How long do I need to preserve my documents, my medical records? What about if a player suffers a concussion but then leaves my team? What's the duty there? Do I have a duty to follow up with that player? And if so, how long does that duty last? What about the SCAT-5, which was the subject of this discussion earlier by Scott Anderson? Is the SCAT-5 required to meet the standard of care? And then we get to reason 4, which is the unresolved science. And that's another reason why these cases continue to get filed. A good example here on the unresolved science, I've handled a number of second impact syndrome cases. Dr. Bales has been a big help in several of those cases. Second impact syndrome, most of you have heard the term. It's when the brain purportedly sustains an impact and then suffers a second before the symptoms from the first resolve, and that's said to lead to catastrophic cerebral swelling. The problem is there are neurologists and well-respected neurologists all across the country, namely Dr. McCrory, who take the view that second impact syndrome is not a viable medical phenomenon, and that makes it easier for plaintiffs to bring these cases because the jury has no idea what to believe. And I recently wrote an article from the legal perspective, Second Impact Syndrome Diagnosis versus Myth, in which I explain how plaintiffs' lawyers are manipulating this concept, this theory of second impact syndrome, to make out the causation theory of a negligence case. And that really is, we've talked a lot about CTE today, that really is the million-dollar question on the unresolved science. Does CTE exist? If it does, how prevalent is it? If it exists, what does it all mean? And we have neuropathologists all across the country taking completely opposite sides, who are on completely opposite sides of the spectrum. Obviously, we have Dr. McKee and her group on one side, and we have neuropathologists such as Lily Nazhizrati, who's been mentioned today, and Dr. Rudy Castellani, who are completely on the opposite side of the spectrum. Chris Randolph, who's been an expert of mine in a number of these cases, one of the nation's leading neuropathologists, recently wrote, and I'm not a scientist, I'm only a lawyer, but he wrote this article entitled "CTE is not a real disease," which I found to be a pretty persuasive piece. So again, the experts are all over the map, and that makes it easier for plaintiffs and plaintiffs' lawyers to bring these cases. And so what does the unresolved science lead to? Well, first of all, it leads to fear. But the second thing that it leads to is a great opportunity for plaintiffs' lawyers and plaintiffs to sue athletic trainers and team doctors in schools and sports organizations whenever a bad outcome can in any way be tied to a prior concussion. So what are the allegations in these cases against the athletic trainers and team doctors in schools? Well, they primarily boil down to these. Very popular allegations in these cases are against the athletic trainer for failure to evaluate, failure to test, failure to monitor. Another popular claim in these cases is failure by the athletic trainer to refer the injured player, who becomes the plaintiff, to a doctor. In the CTE cases, and Dylan's going to talk a little bit more about the CTE cases, failure to warn and failure to educate are the most common allegations, specifically that the school, the organization, did not warn or educate the player who becomes the plaintiff of the long-term effects of concussions. And these CTE cases, these class actions and these individual cases are now being filed all across the country. The first such case to go to trial was the Pletz case. And Dylan's going to talk a little bit more about that, and he's also going to talk about the Schmitz case. The theory of liability in these CTE cases are similar to the theories of liability in the second impact syndrome, the subdural cases. Failure to warn, failure to educate, premature return to play. But the theory of causation is CTE, somehow that the alleged failures, the alleged negligence is leading to CTE, and somehow that the CTE is leading to the player committing suicide. And we just handled one such case. I was contacted by Dartmouth College to represent Dartmouth in a case involving the NCAA, which also was named a defendant. And I alluded to this case earlier. After Patrick Risha tragically committed suicide, his mother Karen filed a lawsuit against Dartmouth and the NCAA, claiming that our negligence led to her son's CTE, and that CTE led to her son committing suicide. And again, it's a tragic case, but we took a very aggressive approach in discovery, and our discovery revealed that Patrick actually was a heavy drug user. He had actually tried to commit suicide even before he got to Dartmouth. And we hired the University of North Carolina, Chapel Hill, which was a huge help. And we did a game analysis of every game, every play in which Patrick was involved. And the net of that result was that Patrick didn't suffer even one concussion on our watch. And we were fortunate enough to get that case dismissed in legal lingo voluntarily with prejudice, which means that the plaintiff could not bring that case again. One of the other reasons why, and this is just a little lawyering 101, why we were so successful, I believe, in getting that case resolved so quickly, is that very early on we undertook a very extensive document collection. And when we do that, we're focusing on the idea that the athlete's complete medical history is relevant. So we want to use, have our experts help us analyzing all neurological test data, radiology studies, and the players' academic records and employment records are very helpful to us in these cases. We also want to track down each and every witness who we can get our hands on, sooner the better, because witnesses' memories fade over time. So we want to reach out to anyone with knowledge. That means the player's teammates, roommates, friends, boyfriend, girlfriend. In the cases of athletic trainer negligence, so many of these cases involve an athletic trainer named as a defendant. We want to reach out to all athletic trainers, assistant athletic trainers, and get their viewpoint and make sure each and every one of these witnesses is memorialized carefully, so when the lawsuit is filed, we've got the witness statements down in a contemporary fashion. So another hallmark of mine in these cases, and many of you have worked with me in the cases that I've mentioned, as soon as I get the green light from the client, I'm reaching out to my go-to experts. So in a CTE case, I'm immediately going to get on the horn with one of my neuropathologists. In a second impact syndrome, my first act is to give Dr. Bales a call and get his preliminary views. If an athletic trainer is sued, I'm immediately going to reach out to a Dr. Brolio or a Scott Anderson and get their views. Strategy development is very important early on in these cases. There's a 2-year statute of limitations, and generally finally, in the event of a catastrophic outcome, you know that a lawsuit's going to be filed, and it's probably going to be filed right around the 2-year point. So you have 2 years to get your ducks in a row. So I do a fair amount of counseling. My firm does a fair amount of counseling. The hope is that you never become a defendant in the first place. And we focus on the idea that you need to be taking, and I'm probably not telling anything you don't already know, that you need to be taking the most conservative approach. But that begins with following your concussion policies and following your concussion protocols. When I first started talking to audiences about a dozen or so years ago, a lot of schools didn't even have concussion policies and procedures on the books. Now almost every big school does, but I'm finding that some schools aren't following their own policies and procedures, and that's going to probably lead to a problem. And it did for the University of Illinois in a case that we just got resolved about a year or so ago. That was a case in which Dr. Bales and Dr. Broglio were experts. That was a case where we represented the University of Illinois' head athletic trainer and others. One of the key issues in that case was whether or not the defendant, our client, violated the standard of care by not conducting the balanced error scoring system test at certain times. And we had, as the defense, a whole host of reasons as to why our athletic trainer, why we did not conduct the BEST test. We argued that it wasn't the standard of care, that it wouldn't have been helpful for a whole host of reasons. But the bottom line was the university's concussion management protocol required that BEST testing specifically be conducted. We didn't, and that's a large reason why that case ultimately settled right before we were scheduled to pick a jury. So another question that I'm often asked is, well, okay, so I understand the standard of care is unresolved, but what are your musts? What are your absolute requirements? And there are several of them, but here are my top 4. One is that you have a concussion management plan on file. Hopefully I'm not telling anything you don't already know. Second, that evaluations be performed by a medical staff member with concussion experience. Number 3, and I think we've touched on this today, no same-day return to play is what we call a black letter requirement. In the event of a concussion, that player is out for at least that day. If you return the player, you're just asking for a negligence problem. And finally, that the athlete be cleared by a physician. In the event of a concussion, that athlete, the potential plaintiff, must be cleared to play by a doctor. Dr. Bales suggested earlier that I would mention this, and I talked about it in a decent amount of detail the last time I was here, but I just want to mention it real quickly, the importance of documentation in these cases, and the adage, if it's not documented, it didn't happen. Because if you're a clinician and you don't keep your mind on that adage, you're probably going to be reminded of it in the event of a catastrophic outcome. It's very important. I've seen cases settle. I've represented clients in cases that we've had to settle because athletic trainers and team doctors did not have the documentation to support what I know the athletic trainer did. But that's what I know. I believe my client, and that's what I know the client did. But juries sometimes are skeptical without the documentation. So it's very important. Another question that I'm often asked is, well, I understand that there are a lot of position statements and consensus statements out there, but what's the most important document? And for that, and I understand this is the Berlin Statement will be updated in next fall, but for now it's the Berlin Statement, the 2017 Concussion in Sport Group Consensus Statement, authored by a number of you in this room, including Dr. Bales and Dr. Broglio. It goes through the 11 R's: recognize, remove, reevaluate, rest. It's the most important document in this area, at least from my perspective. And I just wanted to throw up on the screen real quickly the remove R, that an athlete with a suspected concussion, and I understand that concussions are hard to identify, but in the event of one, the player needs to be removed from play, evaluated by a doctor, not left alone, and again, in the event of a diagnosed concussion, not be returned to play that day. So we've got the Berlin Statement in the upper left. The American Academy of Neurology has its own position statement. That's the top right. NATA recently, well, I guess the original position statement was 04, was updated in 2014. Dr. Broglio was the lead author of that one. And the NCAA, bottom right, has its own guidelines, and the American Medical Society for Sports Medicine just updated its position statement. So that's a lot out there. So I'm often asked, do we really need to be familiar with all of this? And unfortunately, the short answer is yes, because it's the one I that you haven't dotted or the one T that you haven't crossed, that in the event of a catastrophic outcome in a lawsuit, that's what the plaintiff's lawyer is going to focus on. So that's very important. So that's the standard of care, and with that, I'll turn it over to Dylan, who's going to talk a little bit more about the unresolved science.
Thanks, Steve. Thank you, Steve. Steve said my name's Dylan Henry, and I work with Steve in representing individuals and institutions in catastrophic sports injury matters. The two big issues that we face every day in our practice are what we're discussing today, the standard of care and the science. And the reason why the science matters to us lawyers is that a plaintiff must show not only that the defendant breached a standard of care, but that breach caused CTE in the CTE cases, which ultimately caused CTE-like symptoms, which ultimately caused death in the CTE cases. Ultimately, it's always death. And there's a lot of causal gaps that the plaintiff must bridge, and in order to bridge those gaps, expert testimony is required. The issue with expert testimony right now is that the science is unsettled and that these theories are untested. Steve touched upon this earlier, and Dr. Solomon did a great job at outlining what we know and, more importantly, what we don't know about CTE. But on this spectrum, we have extremes. On the one extreme, we have experts essentially finding CTE in almost every brain they examine. On the other side of the extreme, we have experts essentially saying that CTE does not exist. The fact of the matter is most experts in the field probably fall somewhere in the middle. That CTE is real, a syndrome, whatever verbiage you want to use. I say it's a thing, but we don't know what causes it and we don't know what it causes. And this divide in the science can be seen in the cases. And a good example case is Todd Ewan's lawsuit right now versus the NHL. Todd Ewan was an enforcer in the NHL for 13 years. He committed suicide in 2015. Lily Nas Hazrati examined his brain in 2015 and found no evidence of CTE. Dr. Hazrati actually testified, was deposed on behalf of the NHL in a subsequent class action head injury lawsuit. In her deposition, she said that there's no causal link, which is an important term of art, there's no causal link between head injuries and CTE, that CTE is not a disease. 3 years later, just last year, Ann McKee and the Boston group examined Todd Ewan's brain and found that he did have CTE, which is the underlying nexus of the lawsuit that's pending right now. So, what do we do when we have experts issuing diametrically opposed opinions? Who's to say who's right and who's wrong? As it relates to the legal world, it's the jury. It's the 10 to 12 lay women, lay men that are plucked off the street that are asked to fulfill their civic duties and sit on an impaneled jury. And the issue, which further complicates the unsettled science, is the fact that these theories have not been tested yet in front of a jury. The Pletz case was going to be a bellwether case. Greg Pletz played for the University of Texas in the 60s and the 70s. He passed away in 2015. We were watching this case. It was going to be the first case to not only go to trial, but go to a jury. It did go to trial, but 3 days into trial, they settled for an undisclosed amount. So that opportunity to get a data point on these theories, it was a missed opportunity, of course. The biggest issue with that is we have no idea how to guide our advice until we actually get these theories tested in front of a jury. And as Steve mentioned, this makes a breeding ground for creative plaintiffs' lawyers to file these lawsuits. It's easier and easier not only to file these lawsuits, but to maintain them past the lower thresholds in the legal proceedings, a motion to dismiss or motion on the judgment on the pleadings. And like the Pletz case, what we're also seeing are lawsuits being brought on behalf of players who played back in the 60s, back in the 70s with decade-old injuries. The lawsuits are being filed today. And a good example of that is the Schmitz case. Typically, you have 2 years to bring a negligent or wrongful death lawsuit. If you hit me with your car, I have 2 years to sue you, or I'm forever barred from doing so. You can't wait decades to bring a lawsuit. But of course, there's always exceptions to the rules. The Pletz case or the Schmitz case is a good example. The lower courts threw out Schmitz's original lawsuit saying they were time barred. He played for Notre Dame in the late 60s, early 70s. He only experienced the onset of CTE-like symptoms in 2012, brought his lawsuit within 2 years in 2014, and passed away in 2015. Again, the lower courts threw out his initial lawsuit saying it was time barred, but just late last year in 2018, the Supreme Court of Ohio said for the first time, the first appellate court to do so, that brain injuries related to concussions or head injuries could be latent, which means your clock only starts to run once there's an onset of symptoms or a diagnosis, or you reasonably believe to know that you have been injured. Again, it was the first appellate court to make such a holding, and under that theory, athletes playing today could bring a lawsuit in 2060, 2070, literally within 2 years of when symptoms have an onset or there's a diagnosis. If other appellate courts follow suit, it has the potential of further opening the floodgates of CTE litigation. Again, this is going to expand the basis, or the base of plaintiffs. Another trend we're seeing that is expanding the base of plaintiffs are lawsuits being brought on behalf of athletes who are younger and younger. And Dr. Bales mentioned the Rydell helmet case, and the Pop Warner and Rydell helmet cases are examples of that. In both cases, the plaintiffs played football in their teens, from 8 to 18 at Pop Warner. They all unfortunately passed away very young at 22, 24, 25. One from drowning, one from suicide, and one from a motor vehicle accident on a motorcycle. These are difficult theories of causation to prove for a plaintiff. It's not just that you have to show, all right, this brain had CTE and therefore we win the day in court. You have to link the gap to the breach in the standard of care. And these are very tenuous causes of action, very tenuous theories of causation. With the suicide, as Steve touched upon in the Risha case, there's a whole host of other factors that have to be considered. And it's a difficult row to hoe for plaintiff's attorney. In the motor vehicle case, the allegations there were the breach in the standard of care led to CTE, and part of the CTE symptoms were behavioral changes, erratic and irrational behavior, and that was expressed by the plaintiff speeding on a motorcycle and dying in a car accident. In the Rydell helmet case, the allegations there were the CTE caused seizures, and the plaintiff unfortunately suffered a seizure while fishing and drowned. Now, all of these cases are ongoing, and they're simmering in this pot of unsettled science and untested theories. Eventually, one of these cases will go to trial. It might not be one of these three, but eventually one of them will go to trial, will go to a jury verdict, and we'll be able to finally see how these theories hold up in the court of law. The science can remain unsettled, but it's up to the 10, 12 men and women of the jury to actually see, who's the most persuasive and who makes the best argument. We did finally get one data point just last week. It's not CTE, but it is head injury related lawsuit. Onishko versus the NCAA. The allegations in that case were Onishko played football for Cal UPenn in the late 90s, early 2000s. He eventually developed ALS, and the allegations there were that NCAA failed to warn about the long-term effects of repeated head injuries, which ultimately led to that ALS. Same plaintiff's lawyer from the Pletz case, Gene Egdorf, who some of you know. Same experts that we've seen on the far extreme. Benet Amalu testified on behalf of the plaintiffs. And just last week, 8 days ago, on Thursday, the jury finally came out and we finally got our first data point, and the jury held that the NCAA was not negligent in that case. Now, it does shed some light, but we still are in the infancy of how the divide in the science and the untested theories impact the legal world. So, how does this affect you? Why does it matter to you? The advice we give to our clients is control what you can control. You can't control the fact, researchers in the room aside, and you're doing a great job. We can't control the fact that the science is unsettled. We can't control the fact that these theories are untested or that there's a broader scope of plaintiffs now with older injuries or younger athletes. But you can control, and Steve harped on this, and it needs to be harped on again, you can control your policies, your procedures, and your practices. So you have to ensure that you have sound written policies in place, and that they're being followed in your practice to a T. Because any inconsistency, one inconsistency alone is enough for a creative plaintiff lawyer to grab onto and take that thing all the way to trial. annually audit your policies. The standard of care is always evolving. That is something you can control to ensure that your policies and your practices are in line with the most up-to-date standards of care. We are often asked to audit clients' policies and work with them to get their procedures up to date. And yeah, one day we'll hopefully all this we'll look back and think, all right, that was an interesting time. But until then, control what you can control, and thank you very much.